Special Agent Marcus Holloway had been with the FBI for 23 years when he walked into a situation that would cost the government $12,300,000 and destroy the carefully constructed narrative of federal authority that had protected him throughout his career. He was 51 years old, experienced enough to know better, but apparently convinced that his badge and his certainty were sufficient justification for any action he took. One Wednesday evening in a quiet residential neighborhood in suburban Washington, D.C., he received a tip from a confidential informant about suspicious financial activity, a tip that was incomplete, unverified, and ultimately false. Armed with that tip and his own assumptions about where such activity originated, Holloway decided to conduct a warrantless search of a private residence. What he did next? Ignoring constitutional protections, dismissing the homeowner's legal expertise, and violating the civil rights of a United States citizen in her own home, would become a textbook example of how federal overreach combined with racial bias destroys careers and costs taxpayers millions. His name was Marcus Holloway, and he was about to learn that a badge does not override the Constitution. Dr. Victoria Sinclair, a 53-year-old civil rights attorney with 2 decades of experience challenging police misconduct and federal overreach, was standing in her own living room on a Wednesday evening when armed federal agents demanded entry to her home. Her law license was framed on her office wall upstairs. Her constitutional knowledge was not theoretical, but hard-won through hundreds of cases. No crime, no involvement, no connection to the tip that had brought them to her door. Just a black woman in a home they had decided to search without a warrant. But to Special Agent Marcus Holloway, her presence, her insistence on her rights, and her calm assertion of constitutional protections were somehow an obstacle to overcome rather than a reality to respect. Before we continue, where are you watching from? If this is your first time here, please hit that subscribe button. Stories like these need to be shared, and your support helps us bring more truth to light. The Ashford Heights neighborhood sits 15 miles northwest of Washington, D.C., separated from the city by tree-lined streets, brick colonial homes, and the kind of careful generational wealth that comes from professional achievement and strategic real estate investment. Homes here run between $1.2 and $2.8 million. The residents are primarily black professionals, federal judges, surgeons, university presidents, corporate executives, and attorneys. The kind of neighborhood that exists precisely because black Americans with resources wanted to build something away from the scrutiny and chaos of the city proper. It's the kind of place where the sound of a car door closing at night carries significance, where neighbors know each other's professional accomplishments, where property values aren't just economic markers, but statements of arrival and permanence. Dr. Victoria Sinclair's home sat on Grandview Lane, a street that curved gently through the neighborhood, lined with mature oaks and maples that filtered the last light of summer evenings into dappled shadows across pristine lawns. Her house was a 3-story brick colonial with white shutters, a circular driveway, and a professional landscape that suggested someone who paid attention to detail, the kind of home that takes decades to build and seconds to search. It was 6:38 p.m. on a Wednesday in late August. The sun was beginning its descent, casting long shadows across driveways. The air held the thick humidity of summer's final week. The neighborhood was in that quiet moment between the end of work and the beginning of evening activities. Someone watering a garden, someone walking a dog, someone pulling into a driveway home from the office. It was exactly the kind of evening where nothing dramatic ever happened, where the primary concern was whether the dinner reservations were confirmed and whether tomorrow's forecast called for rain. It was the kind of evening where the Constitution was assumed to be in effect and federal agents were assumed to follow the law. Dr. Victoria Sinclair was standing in her living room, reviewing briefs for a federal appeal she was arguing the following week, her reading glasses perched on her nose when she heard the vehicles arrive. Dr. Victoria Sinclair had been a civil rights attorney for exactly 23 years. 23 years of federal court appearances, constitutional challenges, depositions in police misconduct cases, and strategic litigation designed to hold government agencies accountable for violations of citizens' rights. She'd graduated from Howard University School of Law in 2001, in the immediate aftermath of September 11th, when civil rights seemed to be evaporating like morning mist under the heat of national security concerns. Instead of joining a corporate firm, instead of pursuing the lucrative path that her credentials made available, Sinclair had chosen the Federal Defender's Office, where she spent 5 years representing indigent defendants, whose cases exposed the systematic disparities in how the criminal justice system treated poor people and people of color. From there, she'd transitioned to civil rights litigation, founding her own firm, Sinclair and Associates, with two colleagues in 2006. Together, they had won 47 settlements against law enforcement agencies, the largest of which involved a pattern of unlawful stops that had cost a municipality $6,900,000. She had successfully argued before the U.S. Court of Appeals for the D.C. Circuit. She had written law review articles on qualified immunity doctrine, on the exclusionary rule, on the constitutional limits of executive authority. She had been named one of the top civil rights attorneys in the nation by the National Bar Association. Her legal expertise wasn't theoretical. It was forged in federal courts against the full weight of government resources and government lawyers. Dr. Sinclair had graduated from Howard with honors, then completed a fellowship at the Center for Constitutional Rights in New York, where she'd studied under legendary civil rights litigators who'd been filing cases since the civil rights era. She'd won the American Civil Liberties Union's David Ritchie Award for her work on police accountability. She'd trained junior attorneys, mentored law students, and testified before Congress about the dangers of warrantless federal searches and the disproportionate impact of federal law enforcement on Black communities. At 53 years old, Victoria Sinclair had achieved exactly what she'd worked toward: respect in her field, recognition from her peers, and the financial security that came from successful litigation. She lived alone in her Ashford Heights home, had no children, and devoted her life to her practice and to the principle that the Constitution meant something, that rights were enforceable, and that federal authority was not limitless. That Wednesday evening, she'd been home since 5:15 p.m., having left her office in Northwest D.C. after a meeting with a client. She'd changed into comfortable clothes, gray linen pants, and a light blue linen shirt, and settled into her living room with her briefcase, case files spread across the ottoman in front of her, her laptop beside her on the sofa. She'd ordered Thai food, which sat in takeout containers on her dining table. She'd poured herself a glass of wine. She was preparing for oral arguments scheduled for the following Thursday before a 3-judge panel of the United States Court of Appeals. The case involved a warrantless search. The irony would later haunt her. She'd done nothing to attract attention. She'd violated no law. She'd made no phone calls, engaged in no suspicious activity, conducted no financial transactions that morning that would justify federal surveillance. She was a woman in her own home on a Wednesday evening, preparing for work, doing exactly what millions of Americans do on any given evening. But to Special Agent Marcus Holloway and the team he'd assembled, her address had become a point of focus. And that focus, based on incomplete information and flawed assumptions, was about to change everything. Special Agent Marcus Holloway was 51 years old. He'd been with the Federal Bureau of Investigation for 23 years, having joined in 2001 straight from a military background where he'd served in military intelligence. He was considered results-oriented by his supervisors, though that orientation often seemed to prioritize velocity over verification, assumptions over investigation. His record in the FBI was marked by what official evaluations called aggressive pursuit of investigative leads and what civil rights observers called willingness to bypass procedural safeguards in the name of efficiency. In his 23 years with the Bureau, Holloway had accumulated a troubling pattern of complaints. 13 complaints over 2 decades. 13. 6 of them involved allegations of racial bias or civil rights violations. 4 had been sustained, resulting in administrative reprimands and mandatory training. The other 9 had been closed with findings of insufficient evidence despite witness statements and documentary proof of concerning behavior. A Hispanic man detained at gunpoint for 3 hours in 2008 because Holloway suspected him of money laundering based on his employment at a check-cashing service. An Asian woman's home searched in 2012 based on a tip that turned out to be fabricated. The search uncovered nothing, and the informant later admitted he'd been lying about a business dispute. A Black physician whose financial records were subpoenaed in 2016 as part of an investigation into healthcare fraud that never materialized and was eventually closed without explanation. A pattern existed, documented, filed, and systematically ignored. Holloway had a history of receiving tips from confidential informants that were later determined to be unreliable. He had a pattern of seeking search warrants based on information that wouldn't have survived judicial scrutiny. He had a documented history of not seeking warrants when he believed the situation was sufficiently urgent, banking on the legal doctrine of exigent circumstances, a doctrine he seemed to interpret expansively. His supervisors noted in evaluations that he should improve his verification procedures and that he sometimes acted on incomplete information. Those notes never translated into meaningful consequences. When Holloway received the tip about financial irregularities connected to an address on Grandview Lane in Ashford Heights, he didn't pause to verify. He didn't confirm the source's reliability. He didn't cross-reference the address against existing investigations. He simply received information pointing to a black neighborhood, made assumptions about what kinds of people committed financial crimes in such neighborhoods, and decided that a warrantless search was warranted. The tip had come from a confidential informant named Raymond Chen, a man with a grudge against a former business associate and a willingness to fabricate stories. Chen had mentioned financial irregularities being run out of a residential address. He'd been vague about details. He'd provided no documentation, but Holloway had heard what he wanted to hear, seen what he wanted to see, and assembled a team for what he characterized as an urgent search of the premises. On the afternoon of that Wednesday, Holloway briefed his team. No warrant had been sought. Holloway believed the situation qualified as exigent circumstances, a legal exception to the warrant requirement based on immediate danger or imminent destruction of evidence. No judge had evaluated that claim. No magistrate had blessed the search. Holloway had simply decided, and the decision had cascaded downward through the chain of command. Agents were assembled. Vehicles were prepared. At 6:35 p.m., they converged on Grandview Lane, 4 SUVs turning onto a quiet residential street, parking haphazardly on the lawn and driveway of a home whose owner had never been investigated, never been charged, and never been suspected of any crime. Dr. Sinclair heard the vehicles before she saw them. The sound of heavy tires on her driveway, multiple doors opening and closing, voices outside giving orders. She set down her briefcase and moved toward the front window. She saw 4 dark SUVs, federal markings on their sides, agents in tactical gear emerging. Her training kicked in immediately. She knew what this looked like. She'd seen it in hundreds of cases. She knew the protocols, the risks, the legal framework that was supposed to protect her. She was Dr. Victoria Sinclair, constitutional attorney, and she knew her rights. She moved to the front door and opened it before they could knock. "Open your door now. This is federal law enforcement. I'm opening it. What is this about? We have authorization to search this property. Step away from the door. Authorization? I want to see a warrant. I'm a licensed attorney. I know my rights. You can see it inside. Move away from the door now, or we remove you. A warrant must be produced on demand. That's the law. I'm not moving. Show me the warrant now, or you're trespassing on private property. We don't have time for this. Agent Holloway has authorized this search based on exigent circumstances. Step back. There are no exigent circumstances in my home. I'm not aware of any investigation. I've committed no crime. Show me the warrant." Sinclair's voice remained calm, but her heart was accelerating. She was a civil rights attorney standing in her own home, being ordered to move aside by federal agents who were refusing to produce a warrant. She was looking at a violation of the Fourth Amendment playing out in front of her. She was witnessing, in real time, the exact kind of federal overreach she'd spent 2 decades litigating against. "We have it inside. Step aside. You cannot enter this home without showing me a warrant. That's constitutional law. That's not negotiable. We need to search the premises. Not without a warrant. Not without a magistrate's authorization. Not without judicial review of probable cause. You want to search my home? You get a warrant." Agent Holloway appeared from behind the group of younger agents, a man in his 50s with the bearing of someone accustomed to obedience. His face tightened when he saw Sinclair standing firm in her doorway. "Dr. Sinclair, I'm Special Agent Marcus Holloway, Federal Bureau of Investigation. We have credible information suggesting financial crimes are being perpetrated from this address. We need to search your home. Credible information. You have a warrant? We're working on exigent circumstances." Exigent circumstances, meaning you don't have a warrant, meaning you didn't go to a judge, meaning you decided on your own that the Fourth Amendment doesn't apply tonight. That's not how the Constitution works, Agent Holloway. Holloway's expression hardened, his jaw tightened. He'd encountered resistance before, but not like this. Not from someone who clearly knew the law, who wasn't intimidated by his authority, who was standing in her own home and refusing to be moved. "Dr. Sinclair, this is a federal investigation. We need your cooperation. My cooperation would be to insist that you follow the law. You get a warrant, you show it to me, you have it signed by a magistrate, and then you search. Until then, you're violating my constitutional rights, and you're violating your own agency's procedures." The neighbors were noticing now. A man 2 doors down had come out onto his porch. A woman across the street had stopped watering her garden. Phones were being pulled out of pockets. The moment was being documented. We can do this the easy way or the hard way. The only easy way is you follow the law. The hard way is you violate my rights, I file a lawsuit, and I win. I've done this before, Agent Holloway. I've won against the FBI. I've won against the Department of Justice. I know exactly how this plays out. This is where bias becomes impenetrable. Agent Holloway had received information indicating financial crime. When he looked at the address, he'd seen a home in a black neighborhood, owned by a black woman, and his assumptions had filled in the rest. The tip had been vague, but his bias had translated vagueness into confirmation. The information had been unverified, but his bias had translated lack of verification into urgency. He wasn't looking at a woman standing in her own home, exercising her constitutional rights. He was looking at an obstacle to an investigation he'd already decided to pursue. You're obstructing a federal investigation. I'm asserting my constitutional rights. Those are not the same thing. Restrain her. The words hung in the air for a moment. Restrain her. The words that would change everything. The words that would be repeated in testimony, quoted in briefs, cited in the settlement documentation. Restrain her. As if a woman standing in her own home, asking for a warrant, was somehow a criminal threat requiring physical force. You cannot touch me. I have committed no crime. I am on my own property. Show me the warrant or leave. The agents moved toward her. She could see the tactical gear, the weapons, the training that told them how to move as a unit. She could see the certainty on their faces, the belief that they were authorized to do this, that their badges overrode her rights. I am recording this. Everyone here is recording this. I am standing in my own home, requesting a warrant, and you are using force to restrain me. Two agents grabbed her arms. She didn't resist. She'd learned that resistance, even passive resistance, would be characterized as obstruction and would give them legal cover. She allowed them to take her arms, allowed them to guide her away from the doorway, and began speaking loudly enough for every neighbor, every phone camera, every witness to hear. My name is Dr. Victoria Sinclair. I am a civil rights attorney. These agents are entering my home without a warrant. This is a federal violation. This is a Fourth Amendment violation. This is illegal. Everyone here is witnessing this. The agents took her to a chair in her living room. They positioned her there, hands on her arms, keeping her seated. Around her, other agents began moving through her home, opening drawers, searching her desk, photographing her documents, treating her private space as if it were a crime scene. You're violating my rights. Where are your financial records? My attorney-client privileged files are in my office. You cannot access those without a warrant that specifically authorizes seizure of attorney work product. You know this. You know this violates ethical rules. You know this is illegal. But they took the files anyway. They photographed documents. They seized her laptop. They searched her bedroom, her bathroom, her kitchen. They spent 3 hours in her home, finding absolutely nothing related to financial crime, finding absolutely nothing that would justify the search, finding absolutely nothing that would connect her to the confidential informant's allegations. They found her law library, her case files, her professional correspondence. They found a woman living a legal professional life in her own home, and they found nothing. At 9:47 p.m., Dr. Sinclair's phone rang while she remained seated in her living room, agents still moving through her home. The caller was Robert Chen, a federal magistrate judge whom Sinclair knew professionally from multiple warrant applications. She'd called him earlier during the search from her cell phone, speaking in clipped sentences while agents were occupied in other rooms. The conversation lasted 3 minutes. By 10:15 p.m., federal judge Robert Chen arrived at the Ashford Heights address, having driven directly from a dinner engagement, his formal attire somehow amplifying the gravity of what was about to happen. He walked directly into Dr. Sinclair's home, past the federal agents who recognized him immediately, and approached Special Agent Holloway with an expression that suggested he'd rarely been more angry in his judicial career. Agent Holloway, what is the legal basis for this search? Exigent circumstances, credible information about financial crimes. Show me the warrant. We didn't obtain a warrant. We believe the circumstances warranted immediate action. Judge Chen's voice dropped to something cold and dangerous, the tone of a man who'd spent 20 years on the bench watching federal power and who'd now witnessed its abuse firsthand. Exigent circumstances, in a private home, based on information you chose not to verify, without consulting a magistrate, without seeking judicial authorization. You violated the Fourth Amendment, Agent Holloway. You violated federal procedure. You violated this woman's constitutional rights. We were pursuing a legitimate investigation. A legitimate investigation conducted illegally. You're going to cease this search immediately. You're going to leave this home. You're going to preserve all evidence that you've seized, and you're going to prepare documentation of exactly what you've taken and what you photographed. And Dr. Sinclair, I deeply apologize on behalf of the federal judiciary. This search was unconstitutional. Judge Chen turned to Dr. Sinclair, who was still seated in her own living room, still surrounded by federal agents who were now receiving orders to cease their activities and exit the premises. Dr. Sinclair, I'm Judge Robert Chen. I can see your home and your constitutional rights have been violated tonight in the most egregious fashion. You have every right to pursue legal action. Every right. Within minutes, the agents began leaving, carrying boxes of seized materials, moving back toward their vehicles. Special Agent Marcus Holloway's authority in that moment evaporated like morning mist. He was no longer in charge. He was no longer making decisions. He was simply the man who'd violated the Constitution in the home of a civil rights attorney with the resources, the expertise, and the determination to make him answer for it. The story broke the next morning. Federal agents execute warrantless search of home belonging to civil rights attorney, an illegally conducted search that found absolutely nothing. Federal judge confirms constitutional violation in federal overreach case. Black lawyer's home raided by FBI without warrant. Civil rights attorney becomes victim of the very abuse she fights against. By noon, the Justice Department had issued a preliminary statement acknowledging that a search had been conducted without proper authorization. By 3 p.m., the FBI had launched an internal investigation into the conduct of Special Agent Marcus Holloway. By 6 p.m., civil rights organizations had issued statements demanding accountability and federal reform. Special Agent Marcus Holloway was placed on administrative leave 2 days later. His badge was confiscated. His access to federal systems was terminated. The weapons he'd carried into Dr. Sinclair's home were taken from him. He was suspended pending investigation, and within 2 weeks that suspension became permanent termination. Dr. Sinclair's legal team, colleagues at her firm and civil rights attorneys she'd worked with for years, filed a complaint with the Office of Inspector General for the Justice Department. They filed civil rights claims under Bevan's doctrine, seeking damages from the federal government and from Special Agent Holloway personally. They documented the pattern of 13 complaints over Holloway's 23-year career. They detailed the 4 sustained findings of misconduct. They traced the 9 cases closed without investigation despite credible evidence. The Department of Justice reviewed the evidence and made a decision that came with a price tag so substantial it would reverberate through federal law enforcement for years. Within 18 months, the government settled with Dr. Sinclair for $12,300,000, $12.3 million, the largest settlement in Justice Department history for a warrantless search of a private home. The settlement included an admission that the search violated constitutional protections. It included findings that Special Agent Holloway had acted without proper authorization. It included acknowledgement that the informant who'd provided the initial tip had no reliable basis for his allegations. The termination letter for Special Agent Marcus Holloway, signed by the FBI's deputy director, was comprehensive. Special Agent Marcus Holloway is terminated from employment with the Federal Bureau of Investigation effective immediately. Agent Holloway conducted a warrantless search of a private residence on August 28, 2024, without seeking or obtaining judicial authorization, without establishing exigent circumstances, and without proper investigation of the underlying allegations. This search violated the Fourth Amendment rights of the homeowner and violated federal law enforcement procedures. Additionally, review of Agent Holloway's personnel file reveals a pattern of 13 complaints over 23 years of service, including 4 sustained findings of misconduct involving racial bias and civil rights violations. Despite multiple training interventions and administrative sanctions, Agent Holloway continued to demonstrate willingness to circumvent procedural safeguards and constitutional protections. His employment is terminated without cause for reinstatement or appeal. Holloway's name was entered into the National Decertification Index. At 51 years old, his federal law enforcement career was over. 23 years of service, 13 complaints, 4 sustained findings, and now permanent removal from any position in federal law enforcement. The confidential informant, Raymond Chen, was investigated and subsequently prosecuted for providing false information to federal law enforcement. He received a 5-year sentence. He'd lied to a federal agent. The federal agent had believed the lie without verification, and the lie had cost the American taxpayers $12.3 million. Do you think federal agents should face criminal charges for warrantless searches? Drop your answer below. Dr. Victoria Sinclair testified before a federal oversight hearing called by the House Judiciary Committee 4 months after the search. Her testimony was methodical, precise, and devastating. I am Dr. Victoria Sinclair. I am a licensed attorney admitted to practice before the U.S. Court of Appeals for the D.C. Circuit. I have litigated civil rights cases for 23 years. I have challenged unlawful searches by local police, state police, and federal law enforcement. I understand the law governing searches and seizures. I understand the Fourth Amendment. I understand the requirements for warrants, the exceptions to those requirements, and the procedures that federal agents are supposed to follow. She paused, looking directly at the committee members. On August 28th, Special Agent Marcus Holloway entered my home without a warrant, without seeking judicial authorization, without establishing exigent circumstances. He did this based on unverified information from a source he didn't investigate. He did this in my neighborhood, in my community, in my home. Another pause. I showed him the law. I cited constitutional protections. I asked for a warrant. He pushed past my requests. He restrained me in my own living room. He searched through my files, my documents, my personal correspondence, and he found nothing. He found absolutely nothing to justify his violation of my rights. Her voice strengthened. I am a constitutional attorney. I have the resources to fight back. I have the expertise to litigate. I have colleagues who would take my case without hesitation. But millions of people don't have those resources. Millions of people don't know their rights as clearly as I know mine. When federal agents violate the rights of people without resources, without legal expertise, without the ability to fight back, those violations often go unaddressed. They go unchallenged. They become routine. She leaned forward. This is not about me. This is about the system that allowed Special Agent Holloway to accumulate 13 complaints over 23 years and remain employed. This is about the system that sustained 4 findings of misconduct and still did nothing meaningful to change his behavior. This is about the system that sent him to mandatory training on racial bias and civil rights. And that training never registered, never changed anything, never prevented him from violating my home. The room was silent. The $12.3 million settlement is accountability. It's important accountability, but it doesn't restore the trust I had in my own government. It doesn't undo the violation of my constitutional rights. It doesn't ensure that the next agent won't make the same decisions. The next supervisor won't ignore the same patterns. The next victim without my resources won't be left without recourse. She paused one final time. The real question is, what changes now? Does the FBI finally investigate agents after 5 complaints instead of 13? Does federal law enforcement finally implement real consequences for sustained findings of misconduct? Does this system finally acknowledge that warrantless searches of homes owned by Black professionals in upscale neighborhoods are not emergency situations? They are expressions of racial bias backed by federal authority? Should federal agents face mandatory criminal prosecution for warrantless searches? Comment your answer. This wasn't just about one evening in August. This wasn't just about one woman's home or one agent's violation of constitutional protections. This was about a system that allowed Special Agent Marcus Holloway to operate for 23 years, despite accumulating a documented record of misconduct. 13 complaints over 2 decades. 13, 4 sustained, 9 closed with findings of insufficient evidence despite documentation that could have sustained all 13. The pattern was clear. The documentation was extensive. But somehow Holloway remained employed, remained authorized to conduct federal searches, remained trusted with the power to violate citizens' constitutional rights. The internal investigation that followed his termination revealed systemic failure at every level. Supervisors who received reports of complaints and took no substantive action, training programs on racial bias and constitutional procedures that were conducted but never assessed for effectiveness. Performance evaluations that noted concerns about procedural compliance, but never tied those concerns to personnel decisions. A system designed to protect federal authority and federal employees, not to protect citizens from federal violation. The Department of Justice faced intense scrutiny in Congress. How had Holloway accumulated 13 complaints? Why had 4 findings of misconduct not triggered meaningful discipline? The Office of Inspector General opened a comprehensive review of FBI practices regarding warrantless searches, exigent circumstances determinations, and the protection of constitutional rights in residential searches. Their findings were damning. Warrantless searches authorized by individual agents without supervisory review were routine in certain field offices. The bar for determining exigent circumstances was interpreted inconsistently and often too permissively. Supervisory oversight of agent conduct was inadequate. Racial disparities in the neighborhoods targeted for warrantless searches were evident in the data. In neighborhoods with majority black populations, warrantless searches were authorized at triple the rate as neighborhoods with majority white populations. The Department of Justice announced reforms. Immediate. Any determination of exigent circumstances must be approved by a supervisory agent and documented in writing with specific factual findings supporting the legal exception. Any warrantless search must be reported within 24 hours to a magistrate judge for post-search review. Any agent with 3 or more complaints within a 5-year period will undergo mandatory federal liability review and retraining. Mandatory implementation of a racial impact analysis program tracking all searches, warranted and warrantless, by neighborhood demographic data, with quarterly reviews flagging disparities. Automatic, federal notification to the Justice Department whenever any FBI agent is terminated for constitutional violations or sustained civil rights complaints. Dr. Victoria Sinclair's case became the catalyst for these reforms. The $12.3 million settlement wasn't just payment for damages. It was acknowledgement of systemic failure. It was the cost of ignoring patterns. It was the price of trusting one agent's assumptions over constitutional protections. Special Agent Marcus Holloway's career was over. That's consequence. The Department of Justice paid $12.3 million to Dr. Sinclair. That's accountability. Holloway's name was entered into the National Decertification Index, preventing him from working in any federal law enforcement capacity. That's permanent removal from power. But money and terminations don't undo the violation of constitutional rights in one's own home. They don't restore the dignity of being restrained in your living room while federal agents search your private files. They don't erase the message that even a constitutional attorney with a federal background couldn't prevent federal overreach when that overreach came backed by a badge and armed agents. The real question is, what changes now? Does the FBI finally implement the reforms that the Inspector General report recommends? Do field offices finally hold supervisors accountable for the oversight failures that allowed 13 complaints to accumulate? Do we finally acknowledge that warrantless searches of homes in black neighborhoods based on unverified tips represent a pattern of federal racial profiling, not coincidental law enforcement activity? Because if we don't fix the system that kept Marcus Holloway employed through 13 complaints, if we don't address the culture that taught him to act without verification or judicial authorization, if we don't implement real consequences for sustained misconduct, then we're just waiting for the next agent, the next unverified tip, the next civil rights violation, the next victim. Comment if you believe this should be law. Federal agents must obtain a warrant before searching any private residence, with warrantless searches permitted only in genuine emergencies, documented by supervisory review, and subject to post-search judicial inspection within 24 hours. And if you think these stories need to be told, if you believe accountability starts with awareness and change starts with pressure, then hit that subscribe button. We're not stopping. We're going to keep exposing these patterns. We're going to keep demanding that federal authority be constrained by constitutional limits. We're going to keep fighting for the constitutional attorneys, the ordinary citizens, the people whose rights deserve protection even when they don't have the resources to fight back. This isn't just about one agent or one search or one victim. It's about all of us and the federal system we're willing to tolerate, about whether constitutional rights mean something or whether they mean nothing when a badge and a team of armed agents decide they don't apply.